is the decision department. They make a decision on the basis of pro se and anti-female. I've had 13 cases before them, and unilaterally they ruled negatively, every one, which is staffed by 7 attorneys, 5 clerks, and 3 typists. The attorneys of the decision department review all appeal and motion decisions as disinterested third parties. That's a lie. They are hardly disinterested, attempting to locate ambiguities, errors, and inconsistencies before they're released to the public. Any problems are referred back to the justices on the case. And the whole thing of oral argument, I don't think Mangano was blowing his stack at oral argument when the appellate division, second division last met here in White Plains, and he was screaming and hollering. And they show obviously that they haven't done their homework, they haven't read the case, they aren't familiar with the facts and circumstances, and they're certainly not familiar with the law. Assisting the justices in processing the court's huge overload is the dedicated staff of the general clerk's office, and they're very nice. That's Andy and Ralph and Nat and Travis, and they're all very nice. They answer queries by the public concerning court rules, and they do a good job of that, filing of papers, perfecting appeals, and other inquiries. Papers submitted for filing are reviewed by the general clerk's office for compliance with statutes and rules, and if in order, are accepted for filing. So now I'm going to read you about the data entry department, and that will be all for this week. The data entry department opens case records for all notices of appeal forwarded to this court by the various county and court clerks within the jurisdiction of the second department. The information stored includes basic data about the particular case, the parties, and their attorneys. This is very hard to read. It's pretty paper. It's all glossy paper. The 600 watts bounces off of it. The information stored includes basic data about the particular case, the parties, and their attorneys. The department also reviews the request for appellate division intervention, which they charge you $250 for. What was I reading you about Americans for Better America? Yeah. That's what courts should do? Yeah. Charge you $250 just to review your case and rule on it, and rule wrong on it, and rule with prejudice. So they also review the request for appellate division intervention form and make corrections as needed to ensure that the information entered into our system is accurate. Okay. That completes all of our announcements. Here's a bad word about UPS. When I finally did get the package, it should have been delivered, and no wonder it wasn't delivered with somebody like that driving the truck. But today, just now, I heard the outdoor open, and I was expecting a knock because I knew that this package was being sent as a special request because they'd messed it up so much before. And then I heard the outside door shut again, and I looked over, and there's the UPS man in the truck. He never rapped on the door and got a receipt as that it was received. So I took the package out and I said, "You're supposed to get a signature that this package was received safely." He said, "Oh, I couldn't find the apartment number." And I says, "Here's the apartment number on the outside of the package," and it was this big, apartment 2A. And so he kept making one excuse after another, and I said, "Why didn't you just fess up? You did the job wrong, you didn't do your job," and so I got his license number. Whether I'll have time to complain or not, I don't know. Here's an interesting sounding magazine, folks, The Conservationist. This sounds very good, so I tell you about it in case you want to subscribe. And The Conservationist is in Latham, New York. That's just outside of Albany. That's where the famous Catholic, Siena, I guess it is, famous Catholic college is. New York State Conservationist in Latham, New York, to see if you want to subscribe to us. $25 for 3 years. The New York State Conservationist brings the wonders of nature, isn't that nice, to your doorstep in 6 magazines a year for just $10. Faced with mounting costs of production and postage, we expect that annual rate to increase. That's nice. We're going to report to you on the law-breaking of Continental Cablevision, Amos Hofstadter, and all those people. And I have a joke to tell you. The panhandler said to the pedestrian, "May I have $20 for a cup of coffee?" And the pedestrian said, $20 for a cup of coffee? Isn't that a lot? And the panhandler says, "Can I help it if I'm a big tipper?" Now, when the plumber came to the door, he said, "Where's the drip?" And the housewife said, "He's upstairs trying to fix a leak." And one candidate is spending $20 million to get his party's nomination, and they may sound like a lot, folks, but it really works out to just $2 a promise. And one candidate promises to balance the budget by tilting the country. Now, no to the courts and everybody else on Continental this weekend because of having to do the Elizabeth Hubbard appellant's reply brief, my appellant's reply brief, and getting that in. The whole weekend was usurped by that. And there was a conference scheduled with Judge Parker on the 21st of February at 4:30 p.m. But Walsh 2, Thomas E. Walsh II, skipped out of town. It was a conference on order to show cause. And so he ran away from that. There's lots of matters to be discussed and decided, and the courts aren't really doing a thing. So I went to the conference whether Walsh 2 showed up or not at 4:30 p.m. And I went to Judge Parker's courtroom, and the place was mobbed. A trial was going on. 2 black youths, again, claiming that they were falsely arrested by the New York State Police. And I heard the testimony of a trooper, and I saw court reporter Sue Goriab, whom I like a lot, and the calendar clerk is Andrew D'Agostino. And he said, "I saw you on TV." And I said, "Oh, where was that?" And he says, "Out in Nassau County." "Oh," I said, "what town?" He says, "Levittown." He says, "My girlfriend, I was out there visiting my girlfriend, and we watched it on Channel 25 at 10 p.m. Friday night." And I said, "Did you hear me mention Andrew D'Agostino?" And he says, "No, and that's what I was waiting for." And so it was very dubious because another case was backed up behind that. And I think another third one where Judge Parker said he'd try to help those people between 4:30 p.m. and 6:30 p.m. And the woman told me, who was waiting, that they come there every day to try to get help. So mine has been postponed until February 27th at 4:30 p.m. in Judge Parker's courtroom on the 6th floor of the new $33 million courthouse, which doesn't have any parking. But that's bad because on the 27th we have a conference with Judge Smith at 3:30 p.m. or 3 p.m. So I'm going to try to see if we can't change that because I don't want to cut Judge Smith short. There is just too much to be done. So that's no good that Walsh 2 skipped out of town because he didn't want to face the order to show cause hearing. And I want the court to know that I don't want them to say, "You notify your adversary." You do that, court, okay? It took me a whole week to get in touch with these people in the Walsh 2 office. Everything is mishandled so badly in that office. And Therese Murphy called up, and I have this on an audio tape, that I don't know what she was upset about, but she ended up by saying, "We're going to ask for sanctions," when I've already asked for sanctions for them for all of their frivolous motions that fell flat on their faces. And it doesn't do any good to ask for sanctions of me because I'm in forma pauperis. And Tress confesses to Judge Parker that she is, although I am of counsel to Mr. Walsh, I am not admitted to practice in the federal district court and therefore cannot appear on his behalf. Rinky-dink. The whole thing is rinky-dink. Okay, here's some more notes to you. Here it is, an order to show cause showing irreparable harm, and every week the irreparable harm goes on and adds up. Excuse for not taking care of the order to show cause, which should have been taken care of immediately when the case was filed, was that Walsh too was claiming that the court didn't have jurisdiction over the defendants, which was a big lie. They did from the beginning. And every day that they go on not taking care of putting this program back on the TV where it should be, they are in violation of Judge Silverman's decision of July 28, 1994. Plaintiff has a statutory right to have her program on TV and it must be returned to TV. They're in violation of that. They're in violation of the Judge Bryant's decision a year later, July 19, 1995. I don't see how a court can be in violation of the law. Where do you go when the court breaks the law? I want Judge Parker or Judge Smith to make Walsh give the plaintiff the address of Douglas Guthrie, fugitive, what his address is. Does he still work for the company? And what is his current address? He's playing games. He's playing fugitive. I went through all of the Continental files. There's 8 of them. And I pulled out all of the papers that I want to discuss with Judges Parker and Judge Smith, if I ever get to see them. This is my argument for February the 21st, which I didn't get a chance to do because Judge Parker was backed up, and now it's the argument for February 27th. When you look at Walsh 2's answer, pathetic answer that came out to my summons and complaint, not one point, not one affirmative defense stands. They have all been squashed. Not one stands. I want sanctions for the time that they have cost me, and for the labor, and for the stress, and for a motion that was turned down in every respect. And I want any further and different relief that the court can give us. Walsh 2 had the wrong law. He had 532E, which is least access. This case is entirely about public access. Walsh 2 does not declare under penalty of perjury. We finally got a letter from Walsh 2 that he is going to represent Ritter, another fugitive. And I want the home addresses of all defendants. That's according to a local rule, Rule 2. I want a temporary restraining order that they stop blocking my program and putting it back to be cablecast exactly where it was. I want a preliminary injunction for the pendency of this action, that they be stopped from restraining my freedom of speech, and they be stopped from not cablecasting the program every week the way it was. That's Rule 68. And I want make goods for all of the programs. 2 programs have been made good. I want $298 million in damages. Rainey on Groundhog Day said that she would try to put in a couple of extra programs every week, and I said that would be delightful, put it in a letter, but she's never telephoned me back and she's never written the letter, so that was bad faith on the part of Diane Rainey. My discovery was supposed to start on October 6th. It's been totally ignored by both the defendants and the court. There still is no discovery on this case, and it's into its 28th week. We don't know where summary judgment stands. I'm the one who asked for a summary judgment because there was no disputed facts and because the defendants didn't have any defense, any meritorious defense or any defense at all. And so that got waylaid, and now next thing we know, Walsh 2 is asking for a summary judgment after Judge Smith has already told him that she doesn't think there can be a summary judgment because in dispute is the fact that there was improper restraint of speech. And Judge Smith left it that she was going to think about that, but we've never heard from her since on that. Glendora works harder than anybody else, and she never gets paid. All she does is just spend. The settlement is up in the air. They think they can settle without paying any money. Well, they can't. We don't know if Ritter received papers. We know that Walsh 2 now represents him, but has he received all of the papers? Did the marshals find Ritter? Do we have an address for Ritter? He has been served. What is his address? And Guthrie is the same. Guthrie's the worst one. He's a fugitive way out. He's been a fugitive from the beginning. He's the one who accepted service personally from Franklin for both himself and for Diane Rainey and for Melissa Cooper. Everybody has been served. Does Walsh 2 represent American Cable? And I say let's get on to the lawsuit. And I go back to what Judge Bryant said to me on February the 18th, 1994. He says, it's too bad that the defendants chose to contest the service. They should have just gone ahead and answered and then gone through the court. He says it's too bad that they did that. Well, it's too bad that Walsh 2 did that. And he can see now why, because the court has ruled against him on every part of his motion to dismiss. The woman in Boston who said she would make sure that the yellow sheets were sent back to the Marshal Service that week went back on her word, whoever that woman was. So the court now has jurisdiction of all defendants, and they have subject matter jurisdiction. Now, there should be no other obstacles, no other delays, and no more bad faith. I want to know, when do we go to trial on Glendora versus Hofstetter, DeLorme, Schleier, Hawthorne, Ritter, et al. Walsh 2 never filed any objections to Judge Smith's report and recommendation, so I guess that must be accepted, which was a total victory for Glendora and a total defeat for Continental. It would have been far better to have accepted the service, and Walsh 2 wants to drop my defendants, and as Judge Bryant told Cablevision, I don't see how you can do that. It's denied. American Cablevision Systems is joined. I don't know, it was left up in the air. Walsh 2 put out 3-4 pages of undisputed facts, but every one of them I disputed. Every one of them was wrong. So I never heard from Walsh 2 again about that. And I never heard again about settlement. Walsh 2 said that he would drop American Cable Systems, joining them as a necessary party if Glendora would, drop the corporate defendants. Well, that shows you right then and there bad faith on the part of Walsh 2. It wasn't necessary to join American Cable Vision Systems of New York, Inc. I would like to know what Judge Smith's thoughts are on an editorial control. She said it was an issue of law. I would like to know what she's decided. She said that she wasn't sure that editorial control was not exercised. The settlement came to nothing. What happened to the court date that we had, February 9th? The settlement, of course, admits guilt on the part of Continental Cablevision. Rainey makes a statement in the newspaper regarding to the TCI must carry lie, that they don't have a problem with must carry because they have plenty of channels and plenty of space, and they don't, time it should be, and they don't have, and she can't ever imagine it being filled up. All right, then why did they take our program down from every week to every other week? You want to know what the Continental signal covers, what towns: Terrytown, North Terrytown, Pleasantville, Mount Pleasant, Bedford, Briarcliff Manor, Newcastle, Austining Town, Austining Village, where Judge Bryant lives. North would be Croton on Channel 19 North would be Croton on Hudson, Buchanan, Pat Buchanan? Peekskill, Cortland, Phillipstown. Who are they? And this leaves 6 across the river, 20 municipalities total, and this is where it is seen now, a Chatwin Glendora. There's always a problem that you don't get a copy of what Walsh 2 sends to the court. He did that on a very important motion that he made to Judge Smith, and Glendora never heard about the motion until Judge Smith sent her denial. Supposing Judge Smith hadn't denied it and granted it, and I would never have heard of it until I got the decision of the judge. I want to know if Judge Smith sees a chat with Glendora. I know that on TV. I know that her clerk, James Galvin, does. I would like $3,000 sanctioned against Walsh 2 for his frivolous motion and for all of the delay and the expense that it costs. I would like $7,000 sanctioned against all the defendants: Hofstadter, Ritter, Nair, Schleier, DeLorme, Guthrie. I remind everybody that the Judge Bryant Court went through extensive litigation and ruled that Glendora has a private right of enforcement of 531E, that no cable operator shall exercise editorial control over public use of channel. And I'd like to remind Judge Smith and Judge Parker that you can't dismiss a pro se's case unless you can prove, unless she's been given a chance to prove beyond a doubt that she doesn't have a claim. Going back to Glendora adds that the lateness and the prejudice of Mr. Walsh 2 caused her with his insufficient attempt to dismiss are the very essence of the doctrine of laches. There was nothing there. There was no substance. It was palpably insufficient from the start, and it lost Glendora special right, Federal Rules of Civil Procedure, Rule 1, just, speedy, and inexpensive. It was palpably insufficient both as a matter of law and as a matter of fact. It had no validity. It was academic. It was in bad faith. It was dishonest. It was hysteria and histrionics, to say nothing of frenetics. He was wrong about everything. It delayed discovery. Glendora pleads for sanctions of $3,000 from Walsh 2 and $7,000 from Hofstadter defendants, including Mr. Ritter. And also Glendora wants to see the franchises. Also, remember that this is a class action representing every public access producer in America. Defendants contradict themselves about first come, first serve. In their rule book, they call it first come, first serve, yet they took our programs off because other people said they wanted their programs off. That's not first come, first serve. They contradict themselves. Defendants are not responsive to the needs of the local community. Glendora's programming is exclusively about Continental's law breaking, yet every other one has to be cablecast on a different cable system in a different community. I hear from fans up in Continental land. I hear from George Coolin. I hear from Mr. Kaufman. I say that American Cable Systems is an alter ego. That whole thing was foolish, and they should be sanctioned for it. In discovery, Glendora has to find out who made the decision, with what authority, what is its genesis, who approved it. But remember, all defendants are liable as managers and officers and board members. Diligent and law-abiding employees would not have broken the law and let it be broken. I want the cost of the cross motion. The judge was silent on them. I wonder if that means I get them. I have a lot of rainy audio tapes I haven't had time to listen to. Conversation of years back. I want to know if I can videotape my conference with Judge Parker or audio tape it. We had the U.S. Post Office incident with Guthrie. where a package from him got into my post office box with no stamp, no canceled postage, and it got in there with, what else was wrong with it? Something else. So Glendora has a statutory right to have her program on TV, and on TV now. The costs so far, I'll give them to you as soon as I come to them. What they've done ever since their answer has been as frivolous and as foolish as their answer. And here are those costs, folks. Let me find them for you. And that's Ginny in the recycle box. This is mailing number 39, volume 8, the 28th week, $743.11 in costs, 352 hours, and that amounts to attorney's fees of at $250 an hour. That Cablevision owes Glendora, that Continental Cablevision owes Glendora. Attorney's fees, $87,937.50. So that completes what happened on the law breaking of Hofstetter and Nair and Ritter and Schleier and Delorme and Guthrie and Nancy Hawthorne and Diane Rainey and Melissa Cooper and Greg Sanders. What happened from February the 15th, 1996 to February the 23rd today, 1996 Friday. And here are some jokes for you. Folks, the cheapest and fastest way to have your family tree traced is to run for political office. And a little girl asked her mother, do all fairy tales begin with once upon a time? Her mother says, no, many fairy tales begin with if I'm elected. And why don't millions of Americans vote? It's because under the Republicans, they can't earn their keep, and then under the Democrats they can't keep what they earn. This is a chat with Glendora, and this is a report on what happened in the law breaking of TCI and Malone and Magnus and the other defendants. I'll read that to you in just a second. But here's a nice Bible passage for you. For by grace are ye saved through faith, and that not of yourselves, it is the gift of God, not of works, lest any man should boast. That's written by St. Paul, Ephesians chapter 2, verses 8 and 9. Here's a joke for you. The woman goes up to the post office clerk, and she says, I want $10 worth of stamps. And the clerk says, what denomination? And she says, Baptist. And do you know why history repeats itself? Why does history repeat itself? Because nobody was listening the first time. Now, Christopher Columbus went in the wrong direction from Spain, looking for India. He landed in the Bahamas, and he decided that he had discovered America. If Christopher Columbus were living today, he'd be working for the United States Post Office. On Friday, I was in the Bryant court all morning, and in the afternoon we did 30 telephone operation calls, things that had been stacked up for, I'd say, 3 months. And it was quite a snowstorm. It was the 19th of the season, and it was 9 inches, and the visibility was practically zero. It was scary. So we got to Lincoln home safely in the ramp. And Saturday was 4 hours to write the Bryant report, what happened in the Bryant court, Cablevision. and to write the appellant's brief for Elizabeth Hubbard, Fund for Modern Courts. And Sunday all day long was finished writing the Hubbard brief and doing the points, and Franklin doing the typing and getting it printed and bound. And Monday I started the appellant's brief against TCI to try to get the Court of Appeals to reverse Judge Connor's order, no temporary restraining order. In fact, what I want is for the Court of Appeals Second Circuit to issue a restraining order. Actually now it would be a preliminary injunction, Rule 65, Federal Rules of Civil Procedure, upon Malone, Magnus, TCI et al. To enjoin them from carrying through any such plan to disturb our public access programs on Channel 8. I want them left just the way they are. Directors and then the people here in Westchester. There was an article Sunday in the newspaper that TCI is going to take away Channel 8 on May 1st. Well, that will, I will, as soon as I get time, get out of the courts for 4 out of 5 days this week, I will go to the United States Court of Appeals where I have this case. It's in 2 courts. You explained to me how that happened. It's just more law breaking and misreading of the rules. I will go to the United States Court of Appeals where my case is already, and I will, instead of, he's TCI, Malone and Magnus have to have their appellee's brief in April the 7th, and my reply brief has to be within 10 days, and then within a week you can expect an oral argument. But I'm going to get on and again ask for an emergency stay, that they not go through with this on May 1st. Number one, they can't go through with it because they haven't applied the 6 months rule. New York Executive Law, Public Service Law now, Article 28, 826. They haven't given 6 months notice. And we don't know where the programs are going to be cablecast from. If they take them away from Channel 8, where are they going to be cablecast from? And in this disruption, they will have violated freedom of speech and expression and freedom of press. Even Judge Connor has admitted that twice. So it will be interesting to see if I get the same panel on my appeal of Judge Connor robbing me and my defendants and letting them get by with a default judgment. It will be interesting to see that. I should have stated that on my notice of appeal. Okay, I'm going to bring that of appeal went to. These TCI crooks did was they decided to accept the service and waive the service. And when you do that, Rule 4, the Federal Rules of Civil Procedure, as Lois Bloom explained it to me, gives them 60 days to answer. And so Wiley Wiles comes through saying that defendants Wicker, Brown, Sullivan, Rich have answered by his motion to dismiss that I didn't receive until February 29th, and by Wiley's reply letter, which it should have been a reply affidavit, he does things very in an amateur way, that they were answering through that sloppy way to do it. And you want to know something, folks, I need time to investigate this, but these people walked into that courtroom, Wiley and Koenig, and they weren't representing any of the parties to the action. Wiley has said repeatedly that he's representing UACC. and UACC is not a defendant, as he has stated their name. And that defendant wasn't added until Judge Connor duped me into adding it. I never should have done that. I never should have conceded that. This is a memorandum by plaintiff protesting Ben Wiles' crooked attempt at joinder received by Glendora March the 24th, 1996. Sunday, mind you, 3 p.m., Glendora states that her reasons follow why Ben Wiles and his court are deviously trying to break the law, joining defendants long after the same have defaulted. 1. The answer of Marshall, Brown, Sullivan, Wicker, and Rich should have been in February 10, 1996. It was not. They defaulted. Then, when this biased court extended time to answer, and Glendora believes encouraged a motion to dismiss to February the 23rd, these defendants never appeared then, so they are in default twice. 3. Wiles is in violation of Federal Rules of Civil Procedure Rule 60B, asked the plaintiff first for an extension, but this court takes away plaintiff's rights lickety-split. Wiles and Koenig walk into Judge Connor's courtroom on January 23, 1996, Tuesday at 9 a.m., and they don't represent anybody who is a party to the action. Can you beat that? What does Judge Connor know? There is no clerk going around getting appearances. Every defendant was unrepresented and defaulted January the 23rd, 96, Tuesday at 9 a.m. And then Judge Connor pressures Glendora to add UACC Columbia Cablevision of Westchester, Inc., DBA TCI of Westchester. He was all wrong to do that to a pro se. And this is when Glendora is already included in the caption, any John and Jane Doe defendants may claim as a necessary party. Judge Connor breezily and questionably writes, according to the docket sheet for this case, the answers of defendants Marshall, Brown, Rich, Sullivan, and Wicker are due no earlier than March the 26th, 1996. Therefore, these defendants are also not in default. Well, really? 6. This is the first Glendora has heard of it. 7. When did Judge Connor arrange this one with the defendants behind Glendora's back over the telephone, the same way he extended their time to answer behind Glendora's back? Produce said docket sheet for this case. Where is the file? In the United States District Court, or is it in the United States Court of Appeals? Please take notice that they join in the notice of motion at all, but such joining was due when? 3/21/96 is way too late. 3/21/96, Kenley was talking to Glendora about Judges Connor signing an order on Glendora's 2 Rule 60B motions. But Kenley didn't tell Glendora that the court had advised defendants, you better get a joinder in. Every morning, Glendora and Franklin ask each other, what will the Judge Connor court do today to get the defendants out of the jam they got themselves into yesterday? How will he get them out of that one? There is no defendant UA Columbia Cablevision of Westchester Incorporated, DBA TCI Cable of Westchester. It is too late for these marshals to rich defendants to join and to rely on the February 23rd affidavit of Wiles signed by Wicker Puppet and on the erroneous memorandum of law and the anemic reply letter of Wiles. They are all in default, January the 23rd, 1996, February the 10th, 1996, and February the 23rd, 1996. The Court of Appeals will find this interesting. All defendants have been personally served by the U.S. Marshal except fugitives Nafee and O'Brien. The court has personal jurisdiction. When did this court give Wiles permission to move to dismiss for lack of personal jurisdiction? This Wiles is as devious, dishonest, and as crooked as they come. Where is the pre-motion conference? Where is Glendora's chance to reply to a request to file a motion? This is getting grotesque. Judge Connor does not follow his own rules. Can you believe infra? And infra is where Wiles says that the service is improper, and yet over here on the other hand, he waives the service. Now isn't there something crooked and devious about that? Would you like that on your record? Crooked lawyers. We are on page 6, and this is from a lawyer who hasn't served plaintiff Glendora with over 10 papers. Nobody yet has approved has appeared for these defendants. Every one of them is in default. Wiles has crashed the party and railroaded it ever since January the 23rd, 1996, and the court is in collusion with him. Glendora wants proof that Wiles represents these people. Proof, no fabrications. Remember, Wiles doesn't ever declare under penalty of perjury. Glendora filed her notice of appeal today of Judge Connor robbing her of her defendants. In yesterday's paper, TCI said May 1st, 1996, they were going to rob us of Channel 8. Glendora will move the United States Court of Appeals, Second Circuit, for emergency stay. March the 21st, 1996, Thursday, 4 to 7 p.m., Malone, Magnus, TCI et al. Exercised 7 more counts of censorship. Daryl Stith and Linda Greco cheated Glendora out of 5 minutes of editing, thus depriving her of freedom of speech and press. The static in the audio was worse than ever, worse instead of better, after Glendora asked them to fix. Linda arrived at 3:58 p.m. The video patches did not work, and the first 4 minutes of Glendora's program number 2041 is black. There has been a short in the patch board since Miles Rich installed it on or about 2 years ago. He has been told several times, and every week it fails. Linda provided no table for Glendora's camcorder number 1, so it was lying with its cords on the floor. Glendora tripped over the power cord, it pulled out, and her program went black again, this time both audio and video. Linda and Daryl, instead of doing their job in the edit and control rooms, were in the studio looking at blood pictures of Reverend Sandberg. Daryl was lying on the studio floor. Franklin is Glendora's witness. It is all on audio tape 782, side 2. When it was time to change 8mm feed tapes into the tie-in, Linda was off the premises, and Glendora had to change them alone when it takes 2 people, and Glendora's program number 2044 went to snow. Linda Greco does not talk to a public access patron as she should. Glendora asked Linda to make up the 5 minutes of editing, 7 p.m. to 7:05 p.m., that Daryl cheated Glendora out of 4 p.m. to 4:05 p.m. Linda was abusive. The next producer never showed up in the editing facilities. That would be John Claude. Lay fallow all that time. Other public access coordinators would not have been as mean as Linda. We went outside in our car until 7:25 p.m. and watched, and nobody came to use the editing facilities. This was just plain censorship, nasty censorship, ever since the lawsuit began on January 3rd, 1996. Glendora has proof of her clean audio tape that she brings in to lay down on the 3/4 inch, and she has proof of the sabotage censorship audio tape that happens at TCI, editing White Plains. The total censorship count is 15. Glendora will report more fully at discovery and at trial. And here is the law they break under color of state. The more they bollocks the production, the more they violate plaintiff's free speech, the more they show Westchester County officials want and work to gag Glendora's bad but true records of them on TV. The public's free speech is abridged also, your right to see these reports and hear them. You could have refused this case, Judge Connor. We cannot see why you did not. Apparently you wanted to help TCI. No cable television company may prohibit or limit any program or class or type of program presented over any channel made available for public access or educational programs. In other words, the cable television franchises shall not exercise, franchisees like TCI, any editorial control over any public use of channel. And then we have due process, demands, mandates an unbiased, impartial judge free from any personal interest in the verdict. They are prohibiting and limiting, TCI is. Then there is 531E that you are charged with enforcing along with Glendora's private right to enforce the same. And here's a whole bunch of laws that TCI has broken. This court has not considered the irreparable harm of loss of our editing rights at the TV studio. May the 1st, 1996 does not comply with the 6-month rule, Section 826. This court dodges the issue. Paul Feiner, supervisor of Greenberg, who discusses revoking the TCI 6 franchises, called Glendora, and she said TCI lied to you and were devious about those franchises. Mr. Feiner did not say differently. Here's a note that was on the tape that they out-censored by turning the audio down so that you couldn't hear the facts about TCI's law-breaking. Glendora called about 12 times to TCI Englewood to find out who was representing Mr. Lone, Mr. Magnus, Clouston, TCI Thompson, Kid Magnus et al. A lawyer said that they hadn't appeared. No appearance. That's default, Judge Conner. This is on audio tape 783-2. The others, people at TCI Englewood, Colorado, dodged, fled, and acted as fugitives. Nobody would give Glendora proof of Mr. O'Brien's alleged death, nor give Glendora Mr. Nafee's address. They are fugitives of law, of service, and of discovery. What amicus Grafman writes here applies to Glendora versus Malone, Magnus, TCI et al. Aptly. Pat Culp put Glendora on hold, then she hung up, and then she ran out of her office. That this dispute is of immense public importance. Plaintiff appellant is appearing pro se in this unusual situation, and amicus curiae brief written by counsel experienced in this field should greatly assist the court and ensure a complete and plenary presentation of the difficult issues therein so that the court may reach a proper decision. Signed, Brian Grafman. Glendora wishes to ask for a partial judgment in her Rule 54B motion. The pro se manual is right about Glendora's case being in two courts at the same time by saying the somewhat complicated procedure is required because generally once a notice of appeal is filed, the district court no longer has jurisdiction over a matter, and all questions regarding the case or the court's procedure should be addressed to the Court of Appeals. Koenig has not produced in writing what he said to Judge Conner, January 23rd, 96, Tuesday at 9 a.m. To 10:15 a.m. on which Judge Conner based his decision to deny Glendora's TRO. Kenley will not tell Glendora what her quote-unquote good notes say. Wiles and defendants are in contempt defying the court and providing the local Rule 2 home addresses. Glendora wonders how it goes in room 623. Kenley tells Judge Conner what Glendora submits. I don't think Judge Conner reads it. He seems to show no knowledge of it. Judge Conner makes his pro-TCI decisions, and Kenley writes them up, and Judge Conner signs them. Glendora does not have time this week to get out her log to the defendants and copies of the 5 legal papers last Tuesday, March 19th, the Rule 54B of March the 22nd, 96 Friday, nor record of the fugitives in Denver. She has an oral argument before the Appellate Division, 2nd Department tomorrow, Tuesday, an argument in White Plains City Court Wednesday, and another oral argument Thursday in the Appellate Division, 2nd Department, and Judge Fox Conference Friday. Doctor said you had a pretty close call there. It was only your strong constitution that saved you. Patient, gee, thanks, docs. Would you please remember that when you write up the bill? I sent a copy of this memorandum to Ben Wiles. Well, folks, I'm back. I'm back from Brooklyn. I got back here at 12:45. I left here at 6 o'clock. I started getting ready. No, 6:20. And I got to Brooklyn. I left at 6:30, and I got to Brooklyn at 7:30. And nobody was dishonest today about the parking meter. I parked for the 2 hours for $1. And I reviewed what I was going to say, which points I was going to say, to the Appellate Division, 2nd Department in Brooklyn on Glendora versus Daniel Walsh, Roberta Walsh, James Walsh, Nella Al Pucci, Theo Al Pucci, Andrew Larkin, and Kevin Larkin. And this case was split in two. They never should have done that. And the Westchester Supreme Court is just one of the dumb things they did, to say nothing of unjust. And the appellate division, after I paid $250 twice for a Roddy, making it $500, the appellate division put it back together and heard it as one argument. I got to the court around 10 after 9, and I sat and I watched the people come into work late. And I talked to the clerks. It was Andy, and Travis was there. I haven't seen him for some time. And Matt, or Nat, and Ralph, and I saw John, and Mr. Gallows retired, and I saw Mr. Rios. And then I saw Mr. Edmund, who feels a little bit better after that terrible slip on the ice. I hope he sues those people and brings them to his own court, the appellate division. No, he'd have to lose a case to bring it to the appellate division. Okay, that he'd win in the Supreme Court. He'd certainly win in the federal court, I would think. Okay. So I was number 9 and 10 on the calendar, and I will show you that. The judges were Thompson and Altman. She's very pretty. And Joy. And Santucci. The first time I'd ever gone before Judge Joy. And I said, it's nice to have a little joy on the bench. And here's my 2 cases. There were 2 people there from Oyster Bay, and I went up and talked to Peter. And he saw my oral argument before the appellate term. And he thought it was good. There's Glendora versus Walsh 1, Glendora versus Walsh 2. And they were so quick. 10:30, I was roaming around the halls, the marble halls with the green marble pillars. And Hank came out and told me, he says, Glendora, your case is coming up. And my goodness, they called it just as I was coming back into the courtroom. And I said, you're so swift this morning. And Thompson says, we're swift every day. And I thanked him for opening the Venetian blinds so I could see to read. It's a lovely courtroom, ornate, Victorian, but too dark, and it's too hard to hear anybody. And Judge Thompson said, now this is about Judge Wood and Judge Ingracia. And I said, yes, Judge Wood first.
For the evils, stand up against the evils of Wood and Ingracia.
The calendar call was planned for 10 o'clock.
Appellant ready, 15 minutes.
The other side did not show up. Wilson Bay did not show up. And so they were unrepresented. All of the defendants were unrepresented. Walsh, Alpucci, and Martin were all unrepresented. Glendora versus Walsh. Good morning, good morning. So swift. They're always swift.
I showed all your pictures on TV and read all your biographies. You're all famous now. I would like to address you this morning. First as to the Judge Wood. The merits are that the record of 2,200 pages speaks for itself. defense and never will have. The lawyers have no defense and never will have. The judge has no defense and never will have. And Glendora was pro se, and the judge was pro lawyer. And then we had law clerk Vengeance Collusion. He's no longer at the Westchester County Supreme Court. He's in Manhattan. Greed came before the temporary restraining order relief for the plaintiff suffering injuries 2,500 times, and Wilson David all in seeking disclosure were guilty of inexcusable laches. And we got juvenile papers by the lawyers. I was used for lawyer training, and Glendora hopes that this court read the 12 volumes of record that I have handed into, and that's why your stacks are so high this morning. I am going over to my shopping list. There is a retirement dinner tonight for Judge Wood given by the Black Lawyers Association. And guess who is the MC? Judge Ingracia. Now, these 2,270 pages of the record show that there is only one decision a court that respects itself can make. Reverse the decision order of Judge Wood. Award Glendora $21,000 with interest from November 11th, 1993, armistice day. Grant her costs, which are about $900 in disbursement, and any other relief that is just, and that's Judge Wood. No, wait a second, I made an error. I'm answering the summary judgment. You couldn't have a summary judgment on something like that. There was raging dispute of the facts. The tail wags the dog, the law firm wags the court. I'm surprised that Wilson Dave didn't show this morning. Koza and Wood were socializing at the Pearl River dinner. The fourth cause of action was entirely ignored. I'd like to win on that, although I know you don't take defaults. Larkins did engage in extreme and outrageous conduct, and it's all on videotape, which nobody saw, which resulted in fear of physical harm. How would you like to go out of your house every day and wonder, are you going to be abused? Yes, every day I went out, 2 or 3 times a day. But Judge Wood never saw the evidence on 8 hours of videotape. Nor did Judge Ingracia, and they were on the TV. Now, sanctions and costs must be imposed upon defendants Andrew and Kevin Martin and upon Wilson Dave, Conboy, Koza, Cousins, McGrath, Odell and Karamitsos for perjury, manipulation of the courts, violation of the judiciary laws, for fraud, for denial of due process, conspiracy, obstruction of equal protection of the law, and for baseless defense when they have no defense. Now look, frivolous. I want to go back to one of your people who was probably here before you were in 1985. Judge Lazar. He said, he ruled, the site is AD 108 and so forth. He ruled that frivolous is in the eyes of the beholder. And you folks wouldn't have before you these new kinds of lawsuits that you have if they had been considered frivolous. There are no grounds to sanction Glendora, not that I think you would, because Glendora is in form of paupers. All of her savings has been spent on her pursuits for justice. There are no grounds to sanction Glendora, not that I think you would, because Glendora is in form of paupers. All of her savings has been spent on her pursuits for justice. And all my points, 6 through 15 in my brief, that I just read you, they weren't challenged. The defendants were never injured. I was the injured one. I just don't understand why this happens in the Westchester Supreme Court. this? Okay, it's the same thing. I'd like the $12,000 cash for the damages these Larkin defendants have done and my costs. Okay, now we go to Judge Ingracia, Angelo J. Ingracia, who is on the appellate term, as you know, and who is our chief administrative judge. Well, Judge Gracia had a job to do, and he never did it. Citizens pay him $115,000 a year to do a job for us, and he backslides. Judge Ingracia did not read the records. He failed to read the 120 exhibits. He never had them. So I know that. James Roberta and Daniel Walsh, even as the record on appeal is being compiled, flaunt the authority of this New York Supreme Court. Two young children is all wrong, reviews Judge Ingracia, failed to do his reading, and when the defendants violated the laws, it was reported on TV. If there were no violations, there weren't any reports on TV. TV or not to be? That's the question. It was their choice. How would Judge Ingracia know? He never read the record. He never saw the videotapes. He was too busy denying plaintiffs due process and equal protection of the law, too busy conspiring with lawyers to get a JHO appointment. Now, he's 72. Wood is 75. Wood is retired. Glendora amply proved her causes of action, and Judge Ingracia does not tell the truth. Dismissed, quote, unquote, with no evidence taken, no witnesses sworn, no testimony taken, and no jury. And the 40 minutes that Judge Ingracia allocated to his decision order is going to cost him 4 years of disgrace made public. Judge Ingracia rules and gives no substantiation. Judge Ingracia violates Glendora's right to equal protection of the law, and the bias of Judge Ingracia is 100%. The first thing that Judge Ingracia said to Glendora before she even opened her mouth was, if you don't like my decision, you can appeal.
Well.
Yeah, and I said, appeal is not an answer to anything. This shows he'd already decided before Glendora was even heard, and Judge Ingracia deprived the law abiders of the relief they should have had, and relieved the lawbreakers of the punishment that they should have received. Surely the Appellate Division, 2nd Department, upon its 100th anniversary, January 2, 1996, in 1 week's time, is not going to let this atrocious decision ordered by Judge Ingracia stand. I want to call quadruple judicial attention. Hear ye, what the Second Circuit United States Court of Appeals, would you folks look at my, or can't you find it with all that up there, on page 46 of the last thing that was submitted to you, which is the appellant's brief. Would you kindly look at that, page 40? Thank you. This is a big decision that I want in the New York, in the United States Court of Appeals. The Glendora, a pro se, it says that this is written by Judge Ben Graceful, in view of the well-settled rule, particularly applicable in pro se civil rights actions, that a complaint should not be dismissed unless it appears beyond doubt that the plaintiff can prove no set of facts in support of her claim which would entitle her to relief. Branham versus Clark and Conley versus Gibson. The court didn't do that. The defendants didn't do that. Don't I get 15 minutes? Thanks for having the Venetian blinds open. Yes, sir, I can see much better. Now, do you have any questions, Judge Thompson? Okay. I don't expect you to read the record. As I said, it's 12 volumes. It's 2,700 pages. Oh, I don't say you could read that. No, do you? I recommend you for a raise. We are down to the, it's nice to have joy on the panel. Okay, we are down to the last thing I have to say, and that's my conclusion. And this is on the Judge Ingracia thing, and I'm going to that dinner tonight. I'm going to ask to speak the other side. Now, we will reward me $42,000 with interest from Armistice Day 1993, and my husband is a veteran. He was at D-Day and he was at BE Day. Will you grant me my costs and my disbursements and any other site is from 2 Corinthians 5:10, and the year is 32 AD. Thank you, sir.
And that was it, folks. That's all there was to it. It's over. It's over. That was my third court appearance this week. Tuesday was the appellate division on Hubbard, Mayapath, Beck, and the Fund for Ancient Courts. Wednesday was the White Plains City Court on a policeman who doesn't tell the truth and who can't observe and doesn't remember anything. And today's was the appellate division again in Brooklyn, and that was Walsh, Alpucci, and Larkin. And tomorrow is the last one this week. It's the last day of the week. That will be 1 p.m. Judge Fox. And that was my 14th appeal and my last one. You got the part that they opened the Venetian blinds for me. Judge Mangano said he would see to it that they did. All right, now, as to the log. Well, I know this week, Monday, Tuesday, Wednesday, Thursday, and Friday, Monday, Tuesday, Wednesday, and Thursday has been a day of peace. Let me read you about last week, give you the stats, and then we are through. Tonight, as you know, I said there's a dinner for Judge Wood at the Westchester Marriott on Terrytown Road. And I will go over and ask if I may speak the other side of both Wood and Ingracia. And as I told you, Ingracia is the Master of Ceremonies tonight. So we add up what happened last week, and Nella parked in the Walsh parking space on Sunday at 6 p.m. The red truck is gone a lot. Snow is predicted today. I'm so happy to be home from Brooklyn before noon, before it starts. And I don't see any dollars, and I don't see much time, except maybe 2 hours, and that would be the videotaping. But today is certainly a different story, and I don't see any costs, $0. That was last week, the week that ended Sunday, March the 24th. So we had joy on the panel, and here's hope. Now all we need is mercy and charity. So that's everything that happened on Glendora versus Walsh, Alpucci, and Larkin from March the 21st spring to today, March the 28th. Isn't she a pretty kitty? Oh, you're so pretty. You're such pretty kitty. And I've been up since 2 a.m. trying to get the videotaping done in time to edit this afternoon at 3 at TCI White Plains, and trying to get this trial ready. And also I want to get my speech ready for the Wood Ingracia dinner tonight. These are the briefs that I read from, and my goodness, their stack this morning was this high because of my record on appeal. The clerks are going to save me one set of the Wood appeal and one set of the Walsh appeal. That's very nice, because that's very expensive. Ooh, and we've been impoverished by it. See that you're doing very much work. No, I can't see that you're reporting to the people what happened and standing up for your rights. The attendant said to the motorist, all terms at this gas station are cash. And the motorist says, oh no, there's a sign up there. Batteries charged. A reporter asked the professor, what was your mother's name before she was married? And the professor said, I had no mother before she was married. A woman was called for jury duty and she refused to serve, and the judge says, "But ma'am, this is a case about a husband whose wife gave him $5,000 for a down payment on a car, and he went to Atlantic City and lost it." She said, "I'll serve. I could be wrong about capital punishment." And Peter says, "I always do my hardest work before breakfast." And John says, "What's that?" Peter said, "Getting out of bed." Very hard for me, in fact for me to report to you what happened on Continental Cablevision, Glendora versus Hofstadter, and Nair, and Schleier, and Townsend, and Ritter, and Sanders, and Guthrie, and Delorme, and Rainey, and Cooper, because I have had no time being in court every day this week to go through the Continental file. I haven't had time to do the filing, put things in their chronological order, date them, paginate them, list what hasn't been done, and remind the court what should be done, and send out a mailing. I've had no time to talk to you about Judge Parker's decision because of the law-breaking of Cablevision and TCI. I've had no time to report to you, I have to do the discovery. I have to answer all the questions. I love discovery. That's okay. I don't mind that. And then tomorrow at 1 o'clock, I have oh no, that's TCI. That's not Continental. But it's Judge Fox. And I really can't tell you what's going on because I haven't had time to work on it. So really it comes down to this. There is no report on the law-breaking of Continental Cablevision because it's been squeezed out of place by the law-breaking of Cablevision and TCI. Jimmy had a birthday party. He invited 2 grandparents and 4 aunts and uncles. His mother said, "Every one of the people you've invited is older." And Jimmy says, "Well, they're the ones with the money." And one of the passengers on a cruise told another passenger that she didn't like her cabin. And why? Well, the washing machine on the wall in her cabin she didn't like. And the other woman says, "That's not a washing machine, that's a porthole." The first woman says, "Oh, no wonder my clothes didn't come back." And the teacher says, "Give me a sentence using the word bewitches." And Billy says, "Okay, you go ahead and I'll bewitch us in a minute." For announcement time, if you have any announcements, let me know. It's a public forum. You have a right to be heard. Easter offering. Can't see the... Okay, I'll come around and show it to you. Isn't that pretty? And Westchester Marriott. I think they're very uncivilized. I wanted the telephone number of the Black Lawyers Association, who's putting on the retirement dinner tonight for Judge Wood, and Judge Ingracia is the Master of Ceremonies, and they wouldn't give it to me. I think that's totally dehumanized. This is not something where I'm going or anything like that. But it was such a beautiful color copy from Office Max that I was just very impressed by it as a creation of God to show it to you. Americans for Legal Form, you people out there in Nassau County, I'd like to have you join them because so many of you have had problems with lawyers, and this is an association that fights the rights that lawyers take away from you, your money, your home, your family. They meet at the end of every month, and then every week I read you a little bit from the appellate division, their first 100 years. And today I was before them. I was before 4 of them on Glendora versus Walsh, Alpucci, and Larkin. And I think that is my last appeal, number 14. And how far did we get? Just a second. There's the court has had other responses to the caseload crisis. One of them is the Civil Appeals Management Program. And I wish they had done that, where they try to get the people to settle and move the case along. It was inaugurated in 1974. This program is designed to encourage appellate case settlement by requiring attorneys for litigants to appear before a judicial hearing officer or referee in an effort to settle the case and thereby avoid or curtail the costly process of pressing an appeal. Enough cases are amenable to this treatment to make the program worthwhile. Thus, in 1994, of 6,179 cases that were conferenced, 1,083, or 17%, were settled. In May 1990, the court computerized all its records, known as the Case Processing Information System. The computer database replaced, now the computer won't work, right? The decades-old practice of recording information on index cards at various locations throughout the courthouse. Currently, information concerning approximately 53,000 pending and decided cases has been entered into the system. Additionally, the court's word processing system has approximately 100,000 documents in line, along with 8 years' worth of documents on disk. Now, you wouldn't have to have all those documents if we had decent judges in the Westchester Supreme Court, like we don't have. We have instead judges like Wood and Ingrassia and Nicolai and Donovan. And Rosado, and more. The court-wide computer system is also used for word processing by court staff and for computerized legal research with Westlaw or Lexis. Okay, so next week I will read you the rest of that page. Here's a picture of Jeanine Pirro's husband, who makes $400,000 a year in Albany lobbying. And her wife is the Westchester County a district attorney. Tenants and neighbors, join this organization. If you are a tenant, unite as tenants against greedy landlords. And let me give you their number. The New York City office is 212-695-4204. The landlords, greedy, have $1 million lobby up in Albany working against you tenants. Conservationists, a New York State publication. Americans for Legal Reform. No, excuse me. Americans for a Better America. Justice should be fair, equal, and not a function of prejudice, bias, or financial benefit to those in the judicial system. And that's what we have today. The legal system handles criminal actions for show, while matters for dough are handled in a manner that harms the public. The legal system is preying upon the public's problems, and these problems are being created because of its dysfunctionalism. Civil suits now take several years with no consideration given to the litigant's lost income, non-productivity, and lost time out of life. Only lawyers and judges' time is important. Who is serving whom? Americans for a Better America. A panel on lawyers. Kill the secrecy on investigations of lawyers. Kill the secrecy. Write to Judge Judith Kay and say you want open hearings on lawyers. Grievances against lawyers, you want to hear them open from the beginning. Everybody else, you hear about from the time they are charged. Why protect the lawyers, who are the crookedest people that we have? This is a participating sponsorship rules and laws for NBC. We have the telecommunications bill. Have you made up your mind about that? What is good about it and what isn't good about it? We have here an announcement from the Center for Judicial Accountability. I hope their number's on the screen for you. Anyway, it's White Plains, 421-1200. 421-1200. Plainly, our first priority is funding. Our application for tax-exempt status has been filed and is awaiting approval, and they got it. They are tax-exempt. You can make donations to them, and I think, unless the income tax law has changed, you can use that as a debit on your income tax form. As soon as we are tax-exempt, we will be in a better position to attract substantial donations from private and public sources. So they are tax-exempt, and so I hope they do it. And they had a good article in the New York Daily News last week. We are presently in the process of identifying private and public funds. Simultaneously, we are identifying individuals whose courage, integrity, and achievements, oh, those are nice words. You don't hear them anymore. Courage, integrity, and achievements make them suitable candidates that serve on our board of directors. The board of directors is the backbone of a nonprofit organization. We are searching our suitable board members who will bring us leadership and vision and whose reputations will further attract major funding. We invite you to recommend the names of individuals who you would like to see on our national board. Send in your nomination in the form of a letter, giving us as much information as possible about the person, providing us with contact information for your nominee. Well, naturally, they want the rich ones. Glendora, Chat with Glendora, has celebrated its 2000th public access program. It began in 1972. Yes, 23 years ago, 24 years ago. That's when public access began. And it's been on public access ever since it began. The Federal Judicial Center. We are so lucky, folks, to have a United States government that has a Federal Judicial Center with the intent of improving the federal courts. How civil cases move through the district courts. Part 1, Introduction. Part 2, Service, Parties, and Pleadings. These are video cassettes. Isn't that nice? Part 3. Tape A. Pre-trial. That's what I'm going through with Continental and with TCI lawbreakers, robbers of public access, robbers of the public's channels. Tape B, pre-trial proceedings. Oh, I want to watch these and I don't have any time. And this one is, whoops, picks up the light, Part 4, Trial and Judgment. This I've seen some of and I never got a chance to finish it because of the law-breaking, lying, and covering up of Cablevision, TCI, and Continental. all of these people who rob your rights. Society hasn't been good enough to these billionaires that take your money and keep raising your rates. No. The Fund for Modern Courts, there's the new director, Gary Brown. And where does that stand? You know, because that was this week's report to you. We're waiting for a decision from the appellate division, and it will probably be along on the end of April. Judge Burroughs to retire early. Good. We need that. And William Specht, retired machinist. Do you know what that is about? And a court allows Viteri to remain on the town board. That was certainly a just decision. Judge dismisses assault case. That's Judge Mary Smith. And the last clipping, Pataki to fill pending vacancy of Burroughs. I do hope that Andrew O'Rourke doesn't get it. What does Andrew O'Rourke know about being a judge? What does he know? He should sit on the bench of the Supreme Court of the state of New York. The good news is that I got my VHS to work. It took me 5 hours. That's the trouble. You buy a machine, you think it's going to do work for you, and then you have to sit down and read the instruction book. Anyway, I got it to work. On the VCR, the Magnavox, the trick is that it has a remote control, and you point it toward the display panel, and on the screen up comes the menu and the instructions what to do. And then you press 0 and 0 again until you see audio, video in. Then you press your play and record buttons. And then you get your copy from 8mm, we'll say, to VHS. And also I learned how to record off the TV, and I had to go down to Wiz, and Ellie wasn't there, but Gary was there, and Kenroy helped me. So we got it all settled, but it took the rest of Sunday practically after church. This I don't like is that Gannett calls Judith Kay for a conference and Judith Kay comes. Okay, I don't think Judith Kay should succumb to that. Judges should be independent of the newspapers. Not that this is, you could really call this a newspaper. We have the county courthouse still being in a swamp, still leaking from the up above and from down below. And I guess that's all the announcements. I'd like to read you a recipe, which I never have time to do because of the law-breaking and covering up and lying of these billionaire cable operators who think they own the United States District Courts. Let's see. Walnut tofu balls. 2 cups of walnuts or pecans chopped fine and toasted on a cookie sheet for 15 minutes at 200 degrees. 2 cups of soft breadcrumbs or seasoned. 1 pound a large block of tofu. Tofu, as you know, is a soybean product. It has no taste at all, but you put it in the recipes and it comes out delicioso. And 3 tablespoons of dough pep or gluten flour or 1 egg. Stick with the flour, stay away from the eggs. 6 tablespoons of minced dried onion flakes, 4 tablespoons of dried parsley, and 3/4 teaspoon of salt. Combine, mash, or knead with hands, roll into balls, and place on cookie sheet. Bake for 25 to 30 minutes at 350 degrees. Serve with spaghetti and tomato sauce or with brown gravy over flat noodles. Wow. Well, I got to do that one. Oh, but when? The Federalist Papers. I wish somebody would put this in large print so I can read it to you. But in general, it's about, is it Alexander Hamilton? It's matter that the accumulations of power in the same hands may justly be pronounced the very definition of tyranny, and this applies to lawyer. 1% of the populations are lawyers. They're in the legislature. They're all over the place. You know, they're like a virus infection, and you can't get rid of them, and you can't recover from them. And that's a tyranny. Get rid of the lawyers. Down with the lawyers. Time, folks, to go down to 500 Pearl Street, the United States District Court, and look up the record of Robert Callaghan and see what he has against him. And I've filed grievances. I hope those enter his record. He lies, 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 and he's a crook. Robert M. Callaghan of Satterley, Stevens, Burke, and Burke. Now, I believe that's all of the announcements. If you have any announcements, you let me know. And I'm going to tell you some jokes, and then we're going to go out with a Bible passage. Folks, there's not much to see in a small town, but what you hear makes up for it. And the mother said, "Did you thank Mrs. Baxter for that nice party that she gave the children?" And the 6-year-old says, "No. When we were leaving, the girl in front of me thanked her," and Mrs. Baxter said, "Don't mention it." And a woman was filling out an application for a credit card, and when it came to the part where you put down your age, she hesitated and hesitated and hesitated, and the clerk says, "Ma'am, the longer you wait, the worse it gets." Now, this is a chat with Glendora, and here's your Bible passage next. This is nice. Now, there are diversities of gifts, but the same Spirit. And there are differences of administrations, but the same Lord. This is 1 Corinthians 12. And there are diversities of operations, but it is the same God which worketh all in all. For to one is given by the Spirit the word of wisdom, to another the word of knowledge by the same Spirit, to another faith by the same Spirit, to another the gifts of healing by the same Spirit, to another the working of miracles, to another prophecy, to another discerning of spirits, to another divers kinds of tongues, to another the interpretation of tongues. But all these worketh that one and the selfsame Spirit, dividing to every man severally as he will. For as the body is one, and hath many members, and all the members of that one body, being many, are one body, so also is Christ. Isn't that nice? This is a chat with Glendora, standing up for rights from March the 21st, the first day of spring, to today, March the 28th, 1996. Thursday. God bless you, and may good things happen to you, and stand up for your rights.
No calls. 12 messages. 8. I would like a free happy book. My name is Edward Ewers, 54 Upwood Street, book 10573, and thank you for your program. But can you get a happy book that come out? It's probably some big cult thing. But message 2:8:36 p.m. Wednesday, March 27th. Message 3. New York Times yesterday also. AP, front page. 12:30.
Message 6:11:28 a.m. Friday, March 29.
Glendora, I assume you're not home. This is Harvey Cash. I haven't touched base with you in a while. Wanted to find out what was happening. When you get a chance, give me a jingle. It's about 11:30 right now. I'll be gone for a few hours, so after 3 o'clock today, if you can. If not, we'll do it next week. No problem. Take care.
Message 7:12:30 p.m. Friday, March 29.
This guy's stupid.
Message 8:11:27 p.m. Friday, March 29. Message 9:11:27 p.m. Friday, March 29. Message 10:11:28 p.m. Friday, March 29. Message 11:11:29 p.m. Friday, March 29.
Yes, hello. This is Joe Boccarosa, Boccarossa. If you have any more happy books, please send them to 11 Orchard, ORCHARD Street, Syosset, New York, 11791. Thank you.
Message 12:11:31 p.m. Friday, March 29. End of messages.
Calendar of the Appellate Division for March the 28th, 1996, Glendora versus Walsh, Wilson, Babe, Comboy, Koza, Cousins, and Glendora versus Walsh, and Bendish never showed. So, and Wilson, Babe never showed at the Appellate Division. Glendora had all 4 judges to herself, and that would be Thompson and Altman and Joy and Santucci. So she had them all to herself, and nobody showed to defend Walsh, Alpucci, and Larkin. Bad people, aren't they? Bad lawyers. Wilson, Babe, Comboy, Koza, Cousins, McGrath, Odell, Karamitzos, nobody showed. Now that was Thursday morning, and whether it was all this driving to the Appellate Division 2 times in 1 week, but whatever, it caused a dull ache in the leg from the hip to the middle of the foot, the metatarsals, and it has lasted ever since that day, Thursday to today, Wednesday. And the attacks come on it, and they're excruciating. You just can't do anything. And about 16 or 17 of them every day. So that's a pain in the leg, to say nothing of a pain in the neck. And Thursday night, Franklin and I went to the dinner for Judge Wood. This man who sold his soul for political gain. And there were approximately 500 people at the dinner, and each plate was $75, and we were told later that 2 people did not show up at one table, and Franklin and I could have had those chairs and eaten a $75 dinner. 150 altogether. Charles Devlin's name tag was not claimed. Judge Holden's name tag was not claimed, and there were about 20 others who didn't show up. I was happy to see Ivan Pinero, and I was happy to see Dean Wood, Judge Wood's grandson, who works in the county clerk's office. Now, these are the good things that they say about Judge Wood. Evans Brewster was there. Evans Brewster never goes to church. He belongs to our church. But in 8 years, I have never seen him there once. And his wife, Patty, makes the most delicious bran muffins on Ash Wednesday breakfast. In Gracia, I heard Nastasi doing the ceremonies. But it was a highly political affair. It was nothing but politics from the word go. It's really disgusting that judges can't live by the judicial code, making $13,000 of your money every year, each one of them, and they can't divorce themselves from politics, and that the whole system is corrupt. And so I had made out these flyers, and we handed them out. And these flyers said differently from what they were saying about Judge Wood. This is what Judges Wood and Ingracia did wrong. Glendora argued before against them this morning in the Appellate Division, 2nd Department, Brooklyn. Judges Thompson, Joy, Altman, and Santucci were the panel. Glendora on March the 28th. So I handed this out. We had 30 of these, and then we mailed one to Judge Wood, and it's a whole list that I've already read you of all of the laws that they have broken. Well, not all of them. I don't think I could list all of them, but several of them, and this is what they did wrong. I just called the Appellate Division, and there is no decision on Glendora versus Walsh, Alpucci, Larkin, and the complaining of Judges Wood and Ingracia. Because of the law-breaking and the lying and the cover-up of Cablevision and TCI and Continental, there hasn't been any time to keep the log up to date. Those are the stats as they were at the end of last week. There hasn't been any time to tell you what happened the whole of the last week. But it has been a week of peace. And it looks to me like we need a white balance. Did you notice how tannish that was? Now watch, here comes the white balance. And the little green light inside of the Canon camcorder says that now we have a white balance. Let's test it out. I guess it's a little better. Maybe we didn't get a good white balance because we weren't putting it on white. So I believe that's it. It certainly has been the week of 3/25. The last week of March has been a week of peace, and there weren't any tortious acts, and nothing changed there. So now what's going on here, we will wait for the decisions of the judges on Walsh, Alpucci, and Larkin. Totally unrepresented by Wilson, Bave, and Bendish. Now I also saw Michael Kozer Tuesday leaning up against the wall of the where they call the where they have the trial assignment part and the motion calendar. And I told him that he owed me $30, Michael Kozer. And of course, he never owns up, and he just looks the other way. Stone is cemented. It looks beautiful. The nice yellow fresh paint in the cellar looks beautiful. But we still don't have any cellar window. In fact, on both sides, on the west side and the east side, we're missing a cellar window pane. Now, isn't that an awful thing to come and spend 15 minutes putting in a new pane of glass? Isn't that really going to hurt somebody? So we'll have to stuff a rag in it if the landlord wants 21 Greenridge Avenue to look like the South Bronx. We'll just have to do that to keep out the cold and the dampness. The dampness is in there, and the furnace doesn't clear it out, and it's beginning to smell. the appellate division, and this is my last time, I hope, is 13th and 14th appeal, Glendora versus Hubbard. There's no decision on that yet. And that panel was Mangano and Ritter and Miller and Pizzuto. We just called the appellate term, First Judicial District, New York Supreme Court, that's the one in Manhattan. Asked if there was decision yet on Glendora versus Michael Gelman. No decision. And that was argued on February 5th, March 5th, April 5th. 2 months and no decision. We're going to stop for some jokes. That if the Lord gives us our daily bread, and if Santa Claus brings our Christmas presents, and if the stork brings our babies, what's the good of having Daddy around? And Joe says that TV is a device that lets folks who haven't a thing to do watch people who can't do a thing. The only persons who will gladly listen to both sides of an argument are the neighbors on the party lines. This is the file on Officer Stead, who is a White Plains policeman who doesn't tell the truth and who doesn't see straight. You know all about the trial that was on Wednesday, and then I didn't have time to do anything about it until Friday morning, and Friday morning very, very early, I got up and I wrote a post-trial memorandum of law. And I will read you that. And it's to the chambers of Robert Friedman, City Court of the City of White Plains, 77 South Lexington Avenue, White Plains, New York. And it's regarding Glendora's falsely accused of passing through a steady red circular light on January 15, 1996, and a violation of her civil rights by the court under color of state. Post-trial memorandum of law written on Friday, March the 29th. Judge Friedman, Glendora's trial started with ex parte and ended with ex parte. Before Glendora arrived in court at 10:30 a.m. on March the 27th, 1996, you had already been influenced behind Glendora's back by White Plains Police Officer Stead and by White Plains Corporation Counsel Henenberry to preclude Glendora's videotaped evidence. Your decision was already made before you heard Glendora. This is an ex parte. 1. At the end of the trial, as you stepped down from the bench 2 hours later and exited the courtroom, Corporation Counsel was at your heels. This is ex parte 2. So you see what Henenberry did. He went in and pounded on Friedman and made Friedman make up his mind for Stead and against the innocent. As the sole trier of fact, there is no way you can reach the correct decision until you ingest the evidence of this incident. Glendora's right to enter a courtroom as a member of the public was violated. A person was on trial, and by the Sixth Amendment to the United States Constitution, that person is guaranteed a public trial. A trial is not public when the public is excluded. Glendora was brutally excluded by a Neanderthal named Denise, court officer number 3146. Glendora's arms still ache from totally unnecessary force applied by said overweight Neanderthal. Further, Ron, court officer 3700, blocked Glendora's entrance to the courtroom. 10:30A to 10:45A. Glendora was carrying no electronic recording equipment on her at the time. She had been stripped of same. She had been stripped of her right to make her own record. And the record's going to cost me $500. Do you think that's just? You have a right to go into a courtroom and make a record. But the judges who do wrong don't want the public to know that. The paranoia of courts being taped is most revealing. They do not want the public to know how bad they are. Ergo, we have another violation of the United States Constitution, First Amendment, freedom of speech and press. The public has a right to know. That's you. That's your First Amendment right that's violated. And ergo, Glendora's free speech and press are thereby violated. Hence we have the perfect setup for Title 42 of the United States Code, Section 1983, because you are acting under color of state. Congress shall make no law abridging speech or press. Glendora is disappointed the Corporation Council dropped its protest to Glendora's having cablecast her videotape of January 15, 1996, Monday, 10:37 a.m. to 10:47 a.m. on or about. This would have been sure grist for the mill next door, United States District Court, Southern District of New York, Judges Bryant, Parker, Connor, Rakoff, Smith, and Fox. All of your New York State Court officers refused their names. More cover-up, more hiding because of doing wrong. It will be number 3146, number 3700, number 3746, and number 469. Glendora got the names Denise and Ron because they called each other by name. Refusal to identify by name is fugitivism. They know they are in trouble. Denise is arrogant, nescient, unqualified, and should be fired. She shows off authority and lacks training. She incites people needlessly. There is no call for what she did. It is no wonder people lose their respect for police, courts, and especially New York State Court officers. Glendora will complain to Judge Lippman, who lives in Rybrook, and whom she videotaped for her program on the 100th anniversary of the Appellate Division, 2nd Department, January 2, 1996, in Borough Hall, Brooklyn. Glendora also videotaped Judge Kay. And here is the Fifth Amendment. No, excuse me. What's going on now? That's Franklin whispering something to me.
Sustained. The objection is sustained. It was asked and answered. Strike that. The same question was posed a little while ago, and I sustained an objection to it then as well. Move on to something relevant, please.
Well, Mr. Judge Washington, I didn't get to find out who made the decision, and I
discovery's a farce, depositions are a farce, the courts are a farce. And their audio system is a farce.
I thought you guys were going to answer my question. What else is going to have 10 minutes? Because I thought you just described it take 10 minutes. When you talked to Mr. Aznar and he told you to take the program off TV that night. What?
I don't recall specifically, would probably ask again what was the content and have you filled out the proper paperwork and did you have a sponsor of the program that was in the subscriber area and answering referring to those questions. That would be in our subscriber area. And then probably take it off the air for no reason.
Did anybody say that's against the law to take the program off because of content?
I didn't say that. I don't really understand that.
And he never said it. This is before I never told you that.
Yeah.
He said so. So I'm just trying to ask you again. Don't you have any idea as to who brought the attention of this program to Mr. Quinn?
No, I do not.
Is it fair to say that Mr. Quinn made the decision and told Aznar and Aznar told you?
To the best of my knowledge, those are the people involved.
But in your conversation with me, you said corporate. That doesn't sound to me like corporate.
No, that was the president of cable operations. That's corporate to me.
What would this want to say now?
Just stay on. Interesting.
Thank you. Mr. Gardner, the conversations that you had with me, I would say there must have been 20, from the mid-year 1993 to the day of the bomb, November 12th. Those conversations make 100% clear to me that the program is 100% accepted. Would you say that is true?
Check to stay.
In the November 12th conversation, you said you never heard anything more about taking a chat with Glendora off the TV until the time you went to Aznar's office on November 12th.
Correct.
You said there was some talk. There was some talk along about the third and fourth program. What was that talk?
The only thing that I know was that I was requested from Joe Eisenhower to inform him about the content of the program, which I did, and I assume that meant that he was discussing it for one reason or another. And the implication to me was that it was about the area of it or not. I mean, that's
The area of it or not?
that's what I considered the talk.
I see.